For Creamer Media, I'm Gia Costella. I'm at BKM Attorneys to speak to Lauren Hastie about the impact of labour brokers on the engineering and construction industries and the new proposed amendments to the Labour Relations Act. Lauren, please take us briefly through the current impact of labour brokers on the engineering and construction industries.
The current impact of temporary employment services at the moment is because the employees are temporary, they're not paid as much, they don't get the same benefits that ordinary permanent employees would get. And obviously this is beneficial for the client as the employer, but it's not really beneficial for employees. There's a lot of outcry because your temporary employees aren't being treated the same as your permanent employees. And this comes into play mainly in dismissals and dismissal procedure, because you've got your temporary employee who's dismissed by the client, who then has recourse against the temporary employment service because they're technically the employer in terms of the LRA. The problem is that the client is the one who dismissed. They're the one who maybe didn't follow fair procedure or dismissed for a substantive reason. So you're putting the temporary employment service in a position where they have to speak for the client who didn't follow the procedure. So that's obviously has a huge impact on the industry. Temporary employees also don't assert their collective bargaining rights. So that's where the trade unions will obviously have a problem, where they want their members, they want people to assert their collective bargaining rights, and often employees are only employed for a temporary period of time, so they're not going to join the trade union. The disadvantage and one of the biggest impacts on any industry is that the employers and the clients are exploiting the employees' rights. That is a generalization, but they often avoid following the procedure, and that's why they choose to go through your temporary employment service. So while there is a huge space for temporary employment services and the benefits that they bring to any employment sector, there's obviously your disadvantages. The benefit of your temporary employment service is that they go and source the employees, they skill them, they introduce them into the workplace, they provide them with opportunities to in time gain permanent employment and gain skills, gain experience, where ordinarily they wouldn't have had that opportunity to start with.
Please tell us a little bit about the new proposed amendments to the LRA, in particular with regards to the temporary employment services.
Some of the new amendments, especially with regard to temporary employment services, is it now creates a more onerous position on the client, and it regulates the position. So your joint and several liability between your temporary employment service and your client, that section has now been expanded on, where instead of it only being where the client contravenes the minimum requirements, for example the BCA, it now provides for any of those contraventions against the LRA. It also provides for definition of temporary service. So you've got your 6 months where an employee is temporarily absent, and your last provision is for a certain category of work. So for example, a certain construction project that's only going to take 8 to 10 months. An additional provision is a temporary employee cannot be treated less favourably than a permanent employee. That's with regards to all benefits. That's obviously going to be quite a contentious issue, because at times that is why you have your temporary employment service. You don't really want to pay the same that you're paying your permanent employee. Unfortunately, that is something that clients are going to have to get comfortable with. So that temporary employees are provided with the same benefits and the same rights that permanent employees have. With regards to the 6-month period, that can be extended as long as there's a justifiable reason. For example, if I have a construction project that was supposed to only take 6 months, it's now going to take 8 months, I will have a justifiable reason for extending that fixed term contract of the temporary employee for a further 2 months without creating the reasonable expectation that ordinarily would have been created in an ordinary permanent situation where you have your fixed term contract employee. An additional amendment, which I feel is quite a significant one as well, is if your temporary employment service exceeds a period of 24 months, you will now have your temporary employee will now be entitled to a severance package for 1 week of each year completed. That obviously was only initially provided for permanent employees. So temporary employees now will have a few more benefits and a few more rights in terms of these new amendments if they're regulated properly. Your fixed term contract for your temporary employee must be given to the temporary employee in writing. So the written particulars must be provided to them so that they're very aware of how long the project's going to take. Are they there for a specific period of time? Are they there for a specific project? What their rights are in terms of the Act. So they will then always be mindful of what they're entitled to and who they would claim against and what their particulars of employment are.